Hey everybody, welcome back to the weekly immigration news recap, where we break down what changed in U.S. immigration this week and what signals came from the Trump administration that could impact your immigration situation if you're a foreign national or your client strategy if you're an immigration practitioner. My name's Finn Reynolds. I'm director of market research at Lawfully and host of this podcast. And today is Thursday, November 13th. It's about 11:25 a.m. Eastern Standard Time, and this episode's going to be released tomorrow morning on Friday, November 14th. To recap the news with me today, I'm really lucky to be joined by Poonam Gupta, who's the founder and principal at Summit Legal. Poonam, welcome, and thank you so much for taking the time to recap the news with me today. We got a lot of stuff from the Trump administration to cover, so I'm excited to get into all of that with you. But before we do, can you just tell folks who are listening who may not know you a little bit more about your background, your current practice, what you all are doing at Summit Legal, and the types of clients that you support?
Sure. Thanks for having me, Finn, and thank you for doing this to help all the people that who cannot take the time for whatever reason to catch up on the immigration news. And immigration has been a hot topic, but more so under this administration. 2025 has been a blockbuster year for immigration, I would say. Um, my background is wide and varied. I grew up and studied in India and moved to the US just before Y2K, went to NYU for my master's, and then pivoted to I did immigration before I went to NYU, and that's where I really got fascinated with US immigration, and then pivoted to working at White and Case on pro bono immigration matters while focusing on corporate litigation, and white collar and bankruptcy and all kinds of litigations. And then in 2008, 2009, pivoted back to immigration full time with White and Case and headed their immigration team for about 8, 9 years before, under the Trump administration, when I moved to head the New York office for BAL and exited there about 2.5 years ago to start my own firm, Summit Legal. And it's been a journey. I've seen the entire gamut of how things have changed through different financial cycles and administrations and so on. So it's been fascinating. And my primary practice is employment-based immigration, where I have supported the FANG and Plus and Fortune 50 to Fortune 500 companies, as well as startups and museums and, you know, extraordinary people. I've been really blessed to work with a wide variety of phenomenal people, not just lawyers, but clients as well, in a broad spectrum of industries from technology, banking, financial services, beauty, education, universities. It's been a pharmaceuticals, healthcare, all kinds, and it's been a wonderful journey. And I am really thankful and grateful that I have the opportunity to work with clients that bring the best in me. And, I'm honored to be part of their journey and help them one on one and provide the white glove service that I had hoped to do and continue to do with my firm. So that's where I'm at, and I'm really grateful to be here and excited to unpack what's been happening this week in immigration with you.
Yeah, absolutely. And I was at BA. I started my career at BAL as a paralegal in the San Francisco office. I think you were a little too high up to have any idea who I was at the time, but that's okay. And but I'm
What
curious.
years were you there, Finn?
2018 to 2020.
Oh, okay. So we may
Yeah,
have overlapped for a little bit, and I knew a lot of people in the San Francisco office. So I may not have known you personally, but that
yeah,
doesn't mean that I didn't know. I mean, I knew every single paralegal in the New York office, and I interacted with them. So no one
yeah.
was too low or too
No,
junior.
it's a big. I was just joking. I was fresh out of. I was hiding in my corner in my little cubicle there in the San Francisco, the Mission Street office.
Yeah.
Uh, But I was going to ask because I also worked at some other immigration law firms. Most of them were fairly large, although BAL was certainly the largest. And obviously, the big corporate immigration law firms have a lot of resources and a lot of unique things they can offer their clients, and that's all great. But you transitioning from White and Case and BAL and now into your own practice, what are some things that you are able to offer your clients now that maybe you just didn't have the chance to when you were working at some of the bigger immigration law firms?
So when you're part of a bigger program and managing a huge program, I mean, even now, the corporate client is the corporate client, but behind every filing is an individual, is a family, is a whole plethora of anxieties and stressors and decision making and whatever that goes into. And while I tried my best to be cognizant of that while managing big programs, it physically and practically was impossible to know every single client's story and to address every single stressor of theirs and to develop a holistic strategy for what was best for that individual as well as for the corporate clients. Now I have that luxury to have visibility not only into the individual employee's personal situation, uh, but also the corporate big picture, right? Are they what are their goals? Are they looking to expand the team? Are they looking to trim their ranks? How does that impact them? How does it impact their employees? How is their compliance? And having, the front seat, if you will, and partnership with a lot of these clients in helping them navigate the complexities of immigration law has been so fulfilling and satisfying. Not that my prior journey was not satisfying or fulfilling, but it was more removed and more high level than it is now. So that's the big difference.
That's amazing and very relevant for the topics we're going to cover today because we were talking about it before we started recording. In 2025, the factors that not just you as an immigration attorney, but your clients, the corporate clients and the individual foreign nationals have to try and follow when it comes to what the government's doing on immigration is insane. And it's not it's there's never been anything like it like we've seen in 2025, including this week, which is what we're going to jump into today. So like I said at the beginning, Poonam and I are going to go through some of the biggest developments that happened in the immigration news this week. We're going to focus primarily on some of the comments in the past couple of days from President Trump himself and then from several senior leaders inside of the Trump administration around the H-1B visa program, sort of the debate that sparked primarily on the right, amongst Republicans who are in power in all three branches of government right now, and talk about the potential implications of what policy could be following and coming down the pipeline from some of those comments, as we've done here throughout the last 5 or 6 months. And then we're going to talk a little bit about some updates in Project Firewall that largely flew under the radar this week, but I think are significant. And then a piece from Stuart Anderson who highlighted the introduction of a new proposed rule that's in White House review right now. We don't know a lot about it, but it's largely speculated to be a rule that's going to aim to restrict at some level or at a full level the current OPT program. So we're going to jump into all that. We're going to save a little time at the end, as we always do, to talk about a trend that's outside of this news cycle, but that Poonam in particular is paying close attention to because it might have an impact on her clients and many of you listening in the coming weeks and months as well. So with all of that, Poonam, are you ready to jump into the first story this week?
Yeah, let's go.
Awesome. I'm going to go ahead and share my screen. We're going to go through a couple of clips in a row here from the Trump administration on the H-1B program, and then Poonam, we'll talk about it afterwards.
Republicans have to talk about it.
And does that mean the H-1B visa thing will not be a big
priority for your administration, because if you want to raise wages for American workers, you can't flood the country with tens of thousands or hundreds of thousands of foreign workers.
You also do have to bring in talent. When
we have plenty of talented people
no, you
here.
don't. No, you don't.
We don't have talented people here.
No, you don't have. You don't have certain talents, and people have to learn. You can't take people off an unemployment line and say, I'm going to put you into a factory where we're going to make missiles, or I'm going to put
How did we ever do it before?
Well,
when you and I were
I'll give you an example. In Georgia, they raided because they wanted illegal immigrants out. They had people from South Korea that made batteries all their lives. You know, making batteries are very complicated. It's not an easy thing and very dangerous. A lot of explosions, a lot of problems. They had like 500 or 600 people, early stages, to make batteries and to teach people how to do it. Well, they wanted them to get out of the country. You're going to need that, Laura. I mean, I know you and I disagree on this. You can't just say a country's coming in, going to invest $10 billion to build a plant, and going to take people off an unemployment line who haven't worked in 5 years, and they're going to start making missiles. It doesn't work that way.
So for those just listening, that was President Trump talking to Laura Ingraham. We have another clip here from Kristi Noem, Department of Homeland Security Secretary, on Fox News, talking about that interview. So we'll play that one next.
What is the administration's position on these visas?
We're going to keep using our visa programs. We're just going to make sure that they have integrity, that we're actually doing the vetting of the individuals who come into this country, that they want to be here for the right reasons, that they're not supporters of terrorists and organizations that hate America. And that's what I think is so remarkable is under the Trump administration, we've sped up our process and added integrity to the visa programs, to green cards, to all of that, but also more people are becoming naturalized under this administration than ever before. More people are becoming citizens because we're not just streamlining and building some processes back into our immigration policies. We're also making sure that these individuals that are coming into our country and get that privilege, that they actually are here for the right reasons. The Biden administration let thousands of terrorists into this country. They opened the southern border. They abused our asylum.
Okay, I'll pause it there. And then last one here from the Treasury Secretary, Scott Bessent, also from yesterday, talking on Fox News about the H-1B program.
20, 30 years, we have offshored precision manufacturing jobs. And the president's point here is, we can't snap our fingers and say, you're going to learn how to build ships overnight. We want to bring semiconductor industry back to the U.S. There are going to be big facilities in Arizona. So I think the president's vision here is to bring in overseas workers where these jobs went.
Who have skills.
Who have the skills, 3, 5, 7 years to train the U.S. workers. Then they can go home. The U.S. workers fully take over.
So do you understand the concern that people have? Hey, an American can have that job. Why you give it to a guy
but an American can't have that job
so
because
it's specific skills.
Because we haven't built ships in the U.S. for years. We haven't built semiconductors. So this idea of overseas partners coming in, teaching American workers, then returning home, that's a home run.
Gotcha. Mr. Secretary, thanks so much.
So, Poonam, obviously a lot that we just played there. We can dig into the specifics of what President Trump and each of those administration officials said. I sort of want to get your overall reaction to the conversation that's happening at the highest levels about the H-1B program, because those comments have since caused a lot of backlash within the Republican Party. There are very prominent Republicans, Governor of Florida Ron DeSantis, Senator Mike Lee, and other prominent senators and congresspeople who are calling for the elimination of the H-1B program through legislation, through congressional action. For the most part, President Trump, Bessent, and Noem defended and said that the H-1B visa program is going to continue to exist. It's necessary. So there's certainly some policy friction there. But for you, what's your overall reaction, and for your clients who may have seen or are following these comments and are wondering what's going on and what it means for their immigration situation or their employees' immigration situations? How do you sort of translate it for them?
So I think there's a lot of immigration chatter on a regular basis, regardless. And this year, 2025, has seen an explosion of that chatter, if you will. And my advice to my clients is until there is something that actually goes into effect, don't panic. Be aware for sure, but don't panic, because until there is a direct impact, there is no action you can take. You can plan for it, sure, but panicking gets us nowhere. The one thing that, or two things rather, that really stood out in all these comments was, and the backlash aside, we can address that separately or not, but the $85,000 cap on H-1B is not changing. So the talk about flooding the U.S. market with tens and thousands of whatever of H-1B workers, there is a limit to how many H-1Bs can come into the U.S. in any given year. That is not changing. Yes, they're talking about the need for H-1B. There is, like, just look at the number of H-1B lottery submissions. There is a need. Like, there are plenty of safeguards. They're talking about H-1B integrity. There are plenty of safeguards within H-1B program to prevent, lowering the wages, if you will. And in fact, I mean, the reality is most H-1B workers are actually more expensive for an employer than a U.S. worker. Employers want to hire U.S. workers. It's only when they cannot find U.S. workers that they have to resort to hiring H-1B workers. And now I can tell you, with the uncertainty around the H-1B program, the number of people that get rejected right off the bat because they need visa sponsorship is astronomical. It's always been the case with some employers, but now the default for employers is, I don't want to deal with this. And companies don't want to hire somebody for 2 months, 6 months, 12 months, even 3 years, and not know. I mean, unless their model is, we'll have attrition in 3 years anyway. So, we'll take what we can. But most employers want to hire for longevity. They want to plan and have resources to implement whatever goals and projects they have and visions they have long term. You can't pivot on a vision because you have to retool and retrain your workforce every couple of years. That's just not practical, and that's super expensive. So H-1B is not cheap. Like, just the government fees alone is way more than legal fees. Like, what a lawyer charges is far less than what the government fees are, especially if you include the premium processing. So I will say that yes, there is a lot of talk, but I think employers need to be mindful of what their business needs are, and the government's going to do what the government's going to do.
It's interesting because a couple of months ago, I was sitting in this podcast in August with a couple of guests, and over the course of a few weeks, we were covering a similar period of comments from top Trump administration officials on the H-1B program. Back then, it was J.D. Vance and it was Secretary of Commerce Howard Lutnick, and both were talking about the H-1B program in a very negative way. And that sort of behind the scenes was starting to stew. We were covering that. Edlo made some comments about an announcement coming from the White House. And lo and behold, in September 19th, everyone knows the day very well, we got not only the proclamation for the $100,000 fee for H-1B visa petitions, but also the Project Firewall was announced. And then a few days later, the full text of the weighted lottery for the weighted selection rule for the H-1B lottery came out, sort of all in a short period there. And so the commentary, the negative commentary, seemed to have policy consequences a month later. And with this president, I think in areas outside of immigration, business leaders are very accustomed to listening very closely to what he says and then adapting sort of their business strategy, or at least coming up with contingency plans based off of whatever sort of direction they think the wind is blowing inside of the administration. And I think more and more now you're seeing that amongst top businesses when it comes to the H-1B program. Walmart a couple of weeks ago came out I think it was a leak. They didn't come out and say it publicly, but it was leaked that they were going to limit their reliance on the H-1B program. Tata Consultancy said something similar. NVIDIA went a different route, said no, they're going to double down on the H-1B despite the $100,000 fee. Most of that is, I think you and I could both agree, is more PR than it is actual in-house immigration and sponsorship strategy. But the point still stands that like what this administration says, what senior leaders in this administration says, I think at the very least, and your advice is sage, wait until something actually happens. Even the $100,000 fee turned out to be not as sweeping as it was originally announced to be, right? But the commentary nonetheless gets business leaders wondering and thinking, okay, well, what comes next as a result of that? And the one thing I picked out of those comments, I'm not sure if curious if you interpreted it the same way, but the way that President Trump sort of described the benefits of the H-1B, and in the way that Secretary Bessent described the benefits of the H-1B, it was the temporary nature of it, right? We need this transitionary period where skilled foreign talent comes in for a temporary period of time, a few years, or Bessent even said 7 years, which is an interesting number if you know the validity period of the H-1B. To come in and train American workers, and that's sort of I think the political cover they're using in defense of the H-1B program and the need for it. Sounds a lot like the L program to me too. So that's something I'm going to be keeping an eye out for. Is the administration going to double down on the L if they're restricting the H-1B? I'm curious if you in sort of in the either on that one or other sort of examples within the fine print of those three officials' comments, for lack of a better term. Was there anything that you picked up where you're like, I wonder what they mean by that?
So my mind goes back to, yes, they're talking positively about H-1B right now, but the reality is that there is the $100,000 fee. There is the weighted lottery rule that is in the pipeline. There is the rule to restrict the duration of status for students, which is the feeder pipeline, the talent pipeline for H-1B. Typically, there are people outside the U.S. that apply for H-1B, but with the 100,000 fee, I think that pipeline's cut off. So then the only source for H-1B then remains students, and that is being cut off. So them coming out and speaking in favor of H-1B, to me, it just sounds like a soundbite more than actual. Like, I'd love to see some pro H-1B policy down the line, but I'm skeptical. I think it's just trying to control all the backlash from all the anti-H-1B measures that this government has introduced in the last 4 to 6 weeks that has really bigger H-1B programs are pivoting because of those. And this may just be a way to calm them down. Like, no, we need H-1B. We're not getting rid of the H-1B, right? But the reality is the policies that have been introduced will curtail the use of H-1B for people that need it the most.
Yeah, and even if this is, I think, significant too, even if there's multiple challenges against the $100,000 fee that we've talked about in this podcast before, and those are still playing out. Even if some of the more restrictive policies that you just listed out don't actually go into place, the fear in the market exists, right?
Okay.
But I think you're right. You said before, like, there's a cap on H-1Bs, 85,000, right? So even the most hardcore H-1B, restrictionists who want the H-1B program to go away, at a regulatory level, that's not going to happen. It would have to be an act of Congress, and nobody's gonna ever bet on Congress to get anything done, let alone anything done on immigration. But the flip side of that is, like, even with this current environment, and a lot of the more restrictive policies going into place. I'm curious if you agree, but I don't see a world where in the next 4 years we still don't always hit the 85,000 per year cap. There's always going to be, there may be fewer registrations in next year's H-1B lottery, but there's no way that it's going to be fewer than 85,000, right? Or fewer than 150,000. And so that'll continue to get reached no matter what. It's just sort of the way that employers in the past have been able to rely on the H-1B for legitimate reasons may no longer be as accessible as before.
I think because of the restriction on the OPT, and what happens with OPT, I think that may impact. I mean, if things stand as they are today, I agree with you. We will hit the H-1B. The numbers will get met. Even with the weighted lottery, even with whatever, yes, the chances of success will be lower, but if there are fewer applicants, then, I remember a time when you could file an H-1B in October, November and still get it, right? Like there was no problem. And I actually remember, like I had the LCA ready and I was going to file an H-1B, and November 22nd, the lottery was met. And I was going to file like a day later or that same day or something. And it was like, we've just missed it. And so but I think if the talent pipeline from F1, if that is turned off, then there is a potential for that we may go back to that time where H-1B lottery is not banned.
Yeah. Let's that's a good segue into talking about that one next. So Stuart Anderson over at Forbes 2 days ago was the first to bring this to my attention in his article, but there's a new proposed rule sitting in sort of the White House review stage right now that is largely believed to be designed to restrict, or as Stuart Anderson points out in the article, even end the OPT and STEM OPT program as it exists currently. And I'll link the article in the show notes as I always do, so you go and read it. I highly recommend that you do. But there's a lot of reasons for that. Why that's very much a possibility. Not the least being that in a Senate confirmation hearing, Joseph Edlow was asked about this directly and said it was his intention to end the OPT program. So there's sometimes you don't need to look for smoke if the fire's right in front of you. Right now, this is all we know about the rule. For those who are watching, I'm showing the OIRA page, and we just know a couple of sentences about the rule, and you sort of get the key, the key words that are common in the Trump administration around immigration, and especially high skilled immigration in general, which is ensuring that the program, the OPT program, aligns with the original objectives of the program, and then also putting regulations in place to address fraud and national security concerns. So in a couple of weeks, maybe in 2 months or so, the full text of this rule will come out, and we'll know more about what its intentions are. But Poonam, you were sort of referencing it there, that this rule would really, if implemented and if it disrupted the current existence of the OPT program, would have a lot of ramifications, both upstream and downstream of the program itself. Maybe you can unpack that a little bit and what you're hearing from your clients on the concerns around OPT and STEM OPT being changed or ended.
So I don't think this is on. Yes, Edlow mentioned this, and something was expected, but up until we see the text of the rule, the proposed rule, I think it's premature to panic. As we were talking, that there will be some restrictions on the OPT, STEM OPT program. What those are remains to be seen. But depending on how extensive those restrictions are, it will have an impact on the H-1B. It will have impact on the competitiveness of American companies globally. It will have an impact on startups and innovation because there is empirical data about the vast majority of startups are started by immigrants, are started by people. I mean, those unicorns are primarily by immigrants. And even if they're started by Americans, they're staffed by immigrants because there aren't enough US workers or students who are interested in doing this. With AI, yes, it's easier for an AI to code and do the grunt work that people were hired to do during the Y2K scenario. But the reality remains that, yes, there are a lot of computer science engineers, but do they have the skills? Do the companies have the inclination and the time, and are they willing to invest the time and money and effort that it goes to training the newbies, if you will? Most people want people with experience already. Where are those coming from? They're coming from people who've already worked and have come to study to the US and live the American dream, if you will. So it's if US companies commit to training US workers, sure, in time there can be enough workers. But with AI, we're seeing more and more companies trimming the junior ranks, trimming the number of people who can do the basic frontline initial roles. And if those initial training pipelines are shut off, where is the middle management going to come from in a few years? That's my concern.
We know because the data is made public by the government which companies are sponsoring the most H-1Bs, for example. Like that information is all publicly available. There isn't the same public database for the companies that are employing the most individuals who are working on F1 OPT or F1 STEM OPT, although generally there's a correlation between if you're sponsoring a lot of H-1Bs, you also have a lot of folks working on OPT and STEM OPT as well. But you and I know from working inside of, you still currently doing it, working with clients, that in many cases, the total, foreign national workforce, not necessarily sponsored workforce, but total foreign national workforce for many of these companies can be 20, 30, 40% individuals on F1 OPT and STEM OPT.
Yeah.
So it makes up a substantial amount of their current workforce. And with the H-1B lottery, and the number of registrations and how difficult it is to secure an H-1B visa, and perhaps even more difficult, with the way the lottery is the way the selection rules is put into place for entry level, folks to secure an H-1B visa. That 1 to 3 year sort of period is really essential, and that's sort of why it was created in the first place,
Correct.
right? Um, of course, I know, and I don't mean to keep trying to draw you into speculation because your advice to your clients is definitely sage. Wait and see until we know what the reality of this proposed rule is before it even goes into effect. Let alone before it even goes into effect. But how are your clients, I think, thinking about their current OPT workforce? There's so many factors at play right now that could threaten that workforce. And is it something that you're working with clients on to sort of see if there's ways to safeguard or make that part of their program more durable?
Again, depending on when and when the rule comes out, the timing of the rule may have an impact on the H-1B lottery registration, decisions. If it comes out before the lottery is run or announced, then I think, depending on what that rule is, there will be an impact. But long term, if the OPT program is curtailed significantly, then I think more and more companies will will have to think about moving operations outside the US unless, like, their stock price is dictated by their quarterly earnings report, which is dictated by how much money they can save or how much money they can make. And investing in training a new crop of people, I don't see that as ever becoming a priority.
Right.
When moving, and I think it's the opposite of what the government wants to do. They want to bring the jobs back into the US, but my sense is that they may be pushing more jobs outside the US and giving advantages to other countries in becoming more innovative, having access to more talent. I mean, proactively, a lot of professionals are thinking, the companies, whether or not they're thinking, and I would be very surprised if the companies are not thinking about operations abroad where they have the wherewithal. But smaller companies have to think about it, may have to start thinking about it as well. It's just a matter of time if this continues on the path that it is on. And that's why I feel like some of the H-1B comments this week may have been more to calm the businesses that, hey, we still need this and it's not going away, as opposed to any real policy down the road.
Okay, but on last story I wanted to cover with you is just some the first sort of official update on Project Firewall, which was announced about a month and a half ago now. We talked about it before, the same day as the $100,000 H-1B proclamation. And in a Fox News article that came out late last week, some reporters over there got an exclusive, interview not off the record, but just like not attributable to anyone specific, about how Project Firewall is going. And DOL, and again, I'll link this for folks who are just listening so you can go and read it. But DOL said they couldn't provide exact details on the investigations that are underway as a part of the Project Firewall initiative, but they say there's 175 current investigations, and they've already accounted for over $15 million in back wages to workers as a result of compliance problems with companies utilizing the H-1B program. I will note, I talked to some former DOL folks about this over the course of this past week, and several of them mentioned that those numbers don't look out of the ordinary in terms of what DOL typically does, and when it comes to H-1B compliance enforcement, and that sure, it could be, layered into the Project Firewall initiative, but it's not like a big splashy number that is out of the ordinary. It's just the first time that DOL has leaked or shared that information with the public. And then I should just note too, Poonam, before I go to you, I was made aware of this article by Kevin Andrews. I don't know if you know Kevin, but he's an immigration attorney as well. And he wrote a newsletter on LinkedIn that I'll link in the show notes as well, covering sort of his analysis of that article, and then sort of gave 6 red flags that companies or practitioners should watch for, of whether or not they may find themselves being a potential target of Project Firewall. So I'll link that in the show notes. But Poonam, for you, my question is, how much is, I'm sure it's incredibly difficult to, like, just with everything happening to on your docket calls with your clients, go through what impacts them and what doesn't. But when it comes to Project Firewall and compliance with DOL, with sort of the H-1B and their perm programs, how top of mind has that been? And are you doing anything differently with them now than you were before, or has compliance always been top of mind for your clients in particular?
I mean, compliance has always been top of mind for me, and I've made it like a high priority for all my clients, um, at least since the Trump first administration, because that's when they came on guns blazing, enforcement, and compliance is low hanging fruit, if you will. And easily accomplished, easily managed, as long as there is a process for it, as long as there are protocols, and there are people who have it's part of their job description to manage it. Whether people follow it or not, I don't want to comment on that, but I'll tell you this from my clients. I proactively make sure I give them, and my team gives them, as complete a compliance file as we can put together, including her, sort of nagging them to give us information. Like public access file has to have benefits information, right? And you can just have one copy of it for the entire public access, entire set of public access files. You don't have to include it in every one, but making sure we get that information and put it in for the client and share with the client the complete public access file as soon as the LCA is filed, as soon as the LCA is submitted, making sure that things are compliant, following all the rules that are required. Some of the red flags that Kevin raised in his article, in his newsletter, are things that are abuses of the H-1B program, and these are not abuses that are new, that have anything to do with Project Firewall. These are abuses, I mean, these would have been non-compliant even prior to Project Firewall. As in your, in your journey as an in the immigration field, it isn't critical to keep the compliance file up to date, flag to the client, what's the end date, what's the destruction date, what's the retention date, and so on, and provide them with the files as soon as is needed. So yes, those red flags, 100% accurate. Yes, they do raise concerns, but DOL has always had that capability to find those non-compliance pieces without use of AI, without use of anything, just looking at the data. And frankly, USCIS has also been proactive in terms of if an H-1B worker is being paid. I mean, the H-1B worker cannot be paid wages below the prevailing wage. So if the company is lying, then they're asking for more trouble if they're lying on their petition, because they're digging their hole deeper and deeper by falling out of compliance. So my advice has always been stay compliant. It's a lot cheaper and a lot easier than defending an investigation. And it's going to take a lot more resources and time and money to defend an investigation than be compliant and present a compliant file to the officer.
100%. And you and I were talking about that before we started recording, that most compliance violations aren't the result of like a company being malicious or underpaying an H-1B employee, for example. Oftentimes it's just like it's a tedious sort of like checkbox that gets missed, completely innocently. And maybe somebody works at a different location than they're supposed to, but they're still getting paid high enough. They just, it's not marked correctly in the path, and that creates an issue. And like you said, and I think your advice and you're showing it in your actions with your clients is very sage, that it's better to take the time to work with your counsel to address that now, as opposed to dealing with the consequences of DOL coming and breathing down your neck, which they claim that they will be doing more and more of throughout the duration of the Trump administration. So
the one thing there that really jumps out at me is DOL gets its funding from the appropriations bill.
Yeah.
I have not heard of any additional appropriations for DOL for this project. Does that mean that they're going to pull resources from other programs and delay the processing of other applications? Or has there been a ramp up in the wage and hour division personnel? There is no follow-up data, if you will, to that. So yes, the labor secretary is personally certifying those investigations, but I think that just adds a layer of bureaucracy and a layer of additional steps that is going to slow any investigation rather than wrap it up, because I'm sure the labor secretary has a lot of things to do than just certify H-1B investigations.
Yeah, it's a very good point, and it's one of the things that if you're going to watch Congress, if you're going to pay attention to Congress for anything as it relates to immigration, keep an eye on if there's some sort of appropriations move to DOL is going to give them additional resources to ramp up these investigation actions under Project Firewall, or like you said in this, there's a lot more ways that they can sort of do this without public knowledge, a shifting of resources within the agency or within between agencies, interagency wise. And we'll certainly keep an eye out for that and talk about it here, and I'm sure you will too for your clients. Poonam, before we go, we always like to spend the last couple of minutes outside of the current news cycle, and you wanted to talk a little bit about something that is hidden but very significant in the proposed rule to end duration of status, which is steaming ahead, is accelerating ahead, and likely will in the next couple of months have a final version of that rule that could be implemented imminently after that.
Correct. And stuck within that rule is a proposal to end deference within USCIS. What that means, longstanding agency policy was that any petition that had been adjudicated was assumed to have been done in good faith and looking at all the facts. Any subsequent filing by the same employer for the same employee for a same or similar role would be given deference, and would basically, that H-1B approval would be primarily an administrative task. Under the first Trump administration, they rescinded that deference policy memo. And as a direct result of that, long-standing H-1B holders got their H-1Bs denied. It impacted H-1B portability. It impacted operations, businesses on all kinds of levels. This time round, and when the Biden administration came into power, they reinstated that policy, and now this administration seeks to rescind that policy again. And I think the wrinkle this time around is that with the $100,000 fee for consular processing, the denial of an H-1B has long-term consequences. And if I may just run through that scenario. Under the Trump administration, I had a client, and this is a live example, where someone who was an H-1B for 14, 15 years with one of the big four moved to a consulting company. And again, employers typically will defer to the employee on whether or not they want to start working for them upon the filing of the H-1B or upon the approval of the H-1B. Prior to that rescission of the H-1B deference policy, a lot of employees would utilize the H-1B portability provisions and start working for the new employer upon the filing of the H-1B petition. So that's what this employee did as well. They started working for the consulting company, and it's like, no, there's no need to premium process this H-1B. I mean, lo and behold, there was an RFE, and the H-1B was denied. The person has no status, has to leave the United States. We refile the H-1B with premium processing, approved within 3 days. Exact same petition, exact same everything. Only difference, we did premium processing instead of regular processing. Get that approved, the person goes, applies for a visa, comes back. So start to finish, there was a disruption to the business for about a month and a half. This time round, once this policy goes into effect, if the same scenario happens, if the employee starts working for the new H-1B employer before the approval of the H-1B, and if that H-1B gets denied and the person leaves the country, the new H-1B petition would be consular notification subject to the 100,000 fee, which in effect means that that person's not coming back. And the company has lost out on talent that they could have in the US, paying US taxes, helping the US economy. And that person's now gone out and left the United States and is not coming back and is going to contribute to some other economy, maybe the same company in a different location or another company. So it's supposedly very minor, but it will, and in addition to that, there will be a lot more H-1Bs that will be challenged, because if there is no deference, then every H-1B petition is a brand new petition, as if this person has never worked in H-1B before, subject to a much higher level of scrutiny. Much more scrutiny means a lot more time, slower processing, more denials, more RFEs, and basically slow down of the entire legal immigration piece, if you will. This is not the H-1B side.
Yeah, maybe thicker applications that you and your team have to prepare on behalf of the clients too, because you know that there's going to be greater scrutiny applied, and that slows things down on your end because you have to collect more information, and yeah, the whole pipeline that slows down. No, it's a very important thing to flag. I'm glad you did, and I'm really glad you gave that ground level example about the implications of not just this proposed policy change / rule change, but also the other factors that are now at play here and have changed the H-1B landscape in just the last 60 days going forward. So it's a really good one. Well, Poonam, I really appreciate you taking the time out of your day to do this. Before we wrap up, for folks who want to get in touch with you, who might want to work with you, what's the best place to do so for them?
Either my email or my LinkedIn. That's the best way. I have my website. You can reach out to me. Schedule a consultation through my website. The link is also on my LinkedIn. So by all means, happy to support and happy to help anyone to navigate this H-1B journey. I would be honored to work with you. But thank you for having me.
We'll put all that in the show notes too for those who are listening. You can reach out to Poonam, and I highly recommend you do. If you've listened to us for the last 45, 50 minutes, you'll know that she is very, very astute and on the ball when it comes to all of these changes. So all of our clients are lucky to have her. Thank you so much, Poonam. We'll have to have you back on again soon, and have a good rest of your week.
You as well. Thank you.